No, Sasha.
So you can just see the main slide?
Yes, that's correct.
And so nothing here on the right screen?
No.
Okay. I'll just message Tiana quickly. I thought you would also be able to see it, but.
Okay. Nicola, I see you've joined. I assume the attendees will be joining the breakout rooms now. Okay. Great. So it's gone 2 o'clock, but I think people are still busy trickling in. So I'm going to just wait a couple more minutes before we start. Thanks.
Hello.
Sorry, just a fair warning before we begin. Load shedding is scheduled for me now. So if I plunge into darkness, sorry.
Thanks to everyone who's just joined. We're just waiting a couple of minutes because the room's only recently opened. So just 1 or 2 more minutes and then I'll be starting. Thanks. Okay, everyone, thanks. Thanks for your patience. I'm going to kick off the panel. Our panel title today is Rights and Accountability in Customary Law, Developments Backward and Forward for Rural Communities. My name is Monica de Souza Lowe, and I'm the Deputy Director at the Land and Accountability Research Centre based at the University of Cape Town. We do work on customary law, issues of land rights, accountability, based mostly in the former homelands and rural communities. We have 4 speakers today. The first presentation will be by Aisha Mutala and Tiana Duda, both of whom are researchers at LARC. Then we'll have a presentation by Vilmian Wickham, who's an attorney at the Legal Resources Centre. And then we have Nokwanda Sitlali, who is also a researcher at LARC. I'm going to ask everyone who is not speaking to please make sure that you're on mute. And Just a note that we are recording the session and it'll be available on the PILG website after today. Towards the end of the last speaker, I'll be posting a little poll in the chat just for fun. So please look out for that. Once we start the Q&A, I'll explain how to use the poll, since it won't be a traditional poll. Yeah, and I'm hoping we have quite a lot of time for discussion afterwards. If you have comments or questions as we go, please do leave them in the chat, and I will open up for hands at the end. So thank you very much, and I'm going to hand over to Aisha and Tiane. Thank you.
Thank you, Monica. And good afternoon, everyone. It's really a pleasure to be here. And thanks to PILG for allowing us to host this panel. So just a quick note from me, I'm expecting load shedding in a few minutes. Well, actually now, so if nobody can see me, I'm really sorry. There's nothing I can do about it. Such is life. Also, I'm a little bit under the weather, so if I can please ask for you to bear with me, that'll really be appreciated. Thank you. So let me just quickly share my screen. I hope everyone can see this. Okay, cool, great. Thanks, everyone. Okay, so my colleague Tiane and I will be discussing what the Traditional and Khoisan Leadership Act means for the rights of traditional communities. So just simply, the Act repeals and replaces laws that previously applied to traditional governance and traditional leadership. It also recognizes Khoisan communities and leaders for the first time in South Africa, which is a really positive legislative development. So the Act was processed by both the National Assembly and the National Council of Provinces over the course of a few years. It was a Section 76 bill, so it had to be processed by both. It was then signed by the President on the 20th of November 2019, and from the 1st of April this year, it has come into effect. Tiane, over to you.
Thank you, Aisha. Next slide. Oh, you're there already. Afternoon, everyone. And my name is Tiane Duda, as you may have heard already. And thank you, PILG, for this opportunity. So I'm going to jump straight into what we find to be the problem with this act, especially for rural communities. And Aisha and I will ping pong between the two of us the problems with the act. So the first one is in Section 63, which focuses on transitioning traditional institutions, positions from old legislation into the new legislation. So the old legislation will be the Colonial and Apartheid legislation, as well as the Traditional Leadership and Governance Framework Act. And the new legislation is the Traditional and Khoisan Leadership Act. Now, the positions and the institutions that are being transitioned would be positions of kings, queens, senior traditional leaders, headmen, headwomen, as well as tribal authorities to traditional councils. However, in this section, you find that actually this section actually recreates the former Bandostans. It does so by retaining structures that were developed by the colonial and apartheid government, but then now give them new name. One of these are tribes which came into being in terms of the Natives Administration Act of 1927. Now, under the new legislation, these structures have been called traditional communities. And the other structures are tribal authorities, which came into being in terms of the Bantu Authorities Act of 1951. Now they've been renamed traditional councils. Next slide, please. So now if you look on the slide, you'll see there are two maps. On the right, you'll see that that's a map of the former Bandostans, and on the left, that's a map of the current traditional councils. So if you look clearly, you will see that actually the two maps are an exact match. They're exactly the same. This is because the boundaries of traditional councils, actually, when they put together, they actually recreate the former Bandostans. Now the problems are tribal authorities were created through the violence of forced removals, and some communities were forced under tribes or chiefs that they do not recognize and that they do not identify with. And many of these disputes are still ongoing even today, where these communities are challenging the legitimacy and the authority of these leaders who remain imposed on top of them. Now, the Traditional and Khoisan Leadership Act, much like its predecessor, the Traditional Leadership and Governance Framework Act, gives traditional authorities authority over the same jurisdiction that jurisdiction of the former tribal authorities. So traditional authorities now have authority over the jurisdiction of or the boundaries of the traditional councils, and anyone who lives within those boundaries, whether that person or that community recognize the leader or not, but they become their subject because they live in this geography over which this traditional leader or traditional council has authority over. Now, taking into account the history of forced removals and the fact that these leadership positions or these traditional leaders over these communities are still contested, this has the impact of losing identities on people. Next slide, please, Aisha. Oh, another point that I forgot to mention, sorry, I also have extra notes. This also means then traditional leaders are now deriving their authority on land instead of deriving it from the people, which actually violates custom, because some of you may remember that there's an idiom in the Southern African Nguni or Bantu languages, which says, Inkosi Inkosi ngabantu, meaning that a chief is a chief through the people. Now, in this new legislation, much as it was in the past legislation, you see that now traditional leaders are deriving their legitimacy from land instead of the people. You may continue, Aisha.
Thank you, Tiani. So there are various other problematic provisions with the Act. So one of them is Section 24. So Section 24 allows for traditional and Khoisan councils to enter into partnerships and agreements with third parties. So it includes municipalities, government departments, and any other person. So what this basically means is that councils will be able to enter into deals concerning land that may affect the land rights of people who are living on and using that land. However, Section 24 does not require a council to get consent from people who will be directly affected by that partnership or agreement. The requirements for consultation in Section 24 are fairly inadequate. Subsection 3 simply says there must be a prior consultation with the relevant community that is represented by the council, as well as a decision in support that's taken by a majority of the community members who are present at that consultation. So limiting a consultation to just one meeting does not reflect the layered customary decision-making processes that people in traditional communities may practice. Also, not requiring consent undermines the Interim Protection of Informal Land Rights Act, known as IPILRA. So IPILRA says that no person may be deprived of an informal right to land without their consent. So just to illustrate how this provision can play out in practice, a council can sign a deal with a mining company without people who will be directly affected actually being able to say yes or no to it. Another problematic section is Section 23 that deals with the financial management of traditional and Khoisan councils. It includes the opening of a government-controlled bank account for these councils. So basically, monies that are going to be paid to the council has to be paid into this account. And this model is known as the D account model. However, it has proven to be flawed, and Wilmeen will speak to this in her presentation, and it's adapted from the Northwest Traditional Leadership and Governance Act. So Section 23 itself does not provide mechanisms for communities to hold leaders and councils accountable for what happens to community money. So whether it is income that's derived from development or mining that's taking place on community land. So we can see that Sections 24 and Section 23 are linked. So the Act would empower council to sign deals that may have very far-reaching financial implications without much community consultation and participation in the decision-making process. So the next problematic section is section 25, and it allows for national or provincial departments to give a role to traditional and Khoisan leaders and councils, with the limitation that the role does not include decision-making power. However, it's not very reasonable to expect that the roles will exclude decision-making. So effectively, this provision will create a fourth tier of government with leaders and councils being allocated governmental powers. Additionally, section 25 is not consistent with section 212, subsection 1 of the Constitution, which says that national legislation may provide a role for traditional leadership at local level. So section 25 is now enabling the allocation of roles at a national or a provincial level. Tiane, over to you.
So these are some FYI provisions, which are also will have a negative impact on rural communities. So the Traditional Leadership and Governance Framework Act established a commission on traditional leadership disputes and claims. The point of the commission was to investigate traditional leadership claims, as some chiefs got their positions by complying with the apartheid government, while those that refused to comply were removed from their positions. So now the commission was supposed to resolve these issues because there are many claims that came. However, the findings of the commission most of them were challenged in court, and some of the disputes are still ongoing. Now, against that background, the Traditional and Khoisan Leadership Act does away with the commission, even though there are these disputes that are still ongoing. And in addition to that, Section 7 of the Traditional and Khoisan Leadership Act makes it illegal for anyone who's not recognized by government to claim to be a traditional leader. Now, this is a problem because, as I've mentioned already, this is in a context where there are disputes of leadership positions that are still ongoing. But then also it puts government recognition above everything and takes away the customary law process or the customary process of contestation of leadership positions, which allows people to influence who becomes a leader. Now, effectively, what you're seeing communities being excluded or eliminated from the process again. And also what's interesting about this provision is the fact that it also illustrates that government is aware that there are ongoing leadership position disputes. However, with the TKLA, they are closing out space which for those disputes to play out. Next slide, please, Aisha. Now, in our conclusion, we look at the impact of the TKLA or the Traditional Leadership and Khoisan Act on rural democracy. What we find is that it is anti-democratic because all the decision-making is done by government and traditional leaders. Communities are completely excluded from all the decision-making. Furthermore, it turns custom upside down because now traditional leaders are more accountable to government instead of the people or the communities. And it also violates the layered decision-making process of customary law. As Aisha has mentioned already, Section 24 only limits consultation to one meeting with the people who are present in that meeting. And furthermore, it turns rural citizens into subjects with limited constitutional rights. How does it do this? It does this by, as I've mentioned already, it excludes people from decision-making, and there's no consent seeking from the communities about decisions or processes that will affect their lives, for example, land. And also there's no accountability to communities with actions that have been taken. And also it locks people in colonial and apartheid geography with no option to opt out, which violates section 30 and 31 of the Constitution, which says that people have a choice to practice the cultural life of their choosing. And also it gives traditional leaders governmental roles which is something that will only happen in the geography that I had shown earlier, which are these areas, traditional communities. And it won't be happening anywhere else in the country. And also it actually violates the constitution, as only the national, provincial, and local government can hold governmental powers as they are elected. Traditional leaders are not elected into position. Therefore, should they abuse those powers, there are no mechanisms of holding them accountable. And Aisha?
Thanks, Tiane. So in response to the dangers posed by the Traditional and Khoisan Leadership Act, the Stop the Bantustans campaign was initiated by the Alliance for Rural Democracy in 2018. During June 2019, a march to the union buildings was held under the banner of the campaign to ask the president not to sign the TKLA into law. So you're welcome to have a look at the websites for more information. And then I just want to leave us with a question for consideration by the group. What kind of traditional leadership do people want? So people want leaders that will be accountable to them, accountable to the people. Additionally, legislation that deals with traditional governance should be rooted in principles of living customary law, which means that it comes from the ground, it comes from the people who practice it in their daily lives, and this has been recognized by the Constitutional Court in various cases. So what are your thoughts on that? Thank you very much.
Thank you, Tiane and Aisha, for a very interesting presentation. I do think it flows very well into what Vumin will be speaking about. As I said in the beginning, for those who joined us a bit late, Aisha Mutala and Tiane Duda are both researchers at the Land and Accountability Research Center. And next we'll be hearing a presentation by Vumin Wickham, who's an attorney and co-lead of the land program at the Legal Resources Center. And Vumin will be speaking to us about a specific case study, findings from the Beloy Commission. Go ahead, Vumin, thank you.
Thank you, Monica, and I trust you can see my slides. Yes, okay, thanks. So good afternoon, everyone, and thank you for being here and sharing your thoughts with us on this very difficult topic. I'm going to talk about one specific case, and it speaks very well to what Aisha and Tiane have just been speaking about. So this is the case of the Bakgatla Bahafela, and in particular, one commission of inquiry into their affairs. Now, I need to say just a little bit about the community to orientate you. The Bakgatla Bahafela is a community, a traditional community in the northwest, next door to Sun City, to the Royal Bafokeng Nation, and to Marikana. And this community has got an extraordinarily interesting history. They straddle actually South Africa and Botswana. But like many communities in South Africa, they have had constant leadership disputes. Since 1996, a man by the name of Nyalala John Pelane, he was ordained as chief at the time. And through most of his reign, there was contestation as to whether he is the rightful chief. So as with all these disputes across the country, and in terms of the Framework Act, these commissions of inquiry were instituted that got experts to hear these disputes and decide in every community who should actually be chief. And in the vast majority of these commission proceedings, the status quo was maintained. So it was very rare for the commission, for any of these commissions to ever say, well, actually the incumbent is not the rightful leader. Astoundingly, in the case of the Bakgatla, that did not happen. So the Commission of Inquiry actually found that Nyalala Pelane was not the rightful chief and recommended to the Premier that he be replaced. Now, unfortunately, Chief Nyalala Pelane was and is an extraordinarily well-connected person. And for the Northwest Premier, this posed a massive dilemma. He could not bear the political fallout of deposing Nyalala Pelane. And so he did what any reasonable politician would do. he instituted yet another commission of inquiry to investigate the very same question again as to who should be the Bakatla leader. And it's this commission, the second commission, that I'm going to speak to. Okay, so just very briefly, why this leadership dispute mattered so much. And really mining in the whole of the Northwest, but certainly on the land of the Bakatla, has been going on for a very long time and is incredibly lucrative. So since 1968, Union Section Mine was extended over the Bakatla land. Royalty payments to the community commenced in 1982, and at the time flowed into the D account that Aisha and Tiani mentioned. This was a creation of the Bophuthatswana government. The D account was this account controlled by the government with sub-accounts for every traditional community, and the idea was this would keep the money safe. In the late 1990s, we had a platinum boom, and of course, the MPRDA from 2006 required mining companies to have 15% and later 26% Black ownership in their mines. And this really opened up an enormous opportunity for a community like Bakatla, who had a control over land and indeed prospecting rights. And so they entered into a series of transactions that I won't go into, but you can take my word for it, it was exceptionally lucrative. So all this to say that whoever is the leader of this community, in effect, can control all these assets. And for this very reason, that leadership position is incredibly important. Now, the commission had the same old terms of reference. It was all about the leadership dispute, but a very savvy advocate that you may have heard of, Advocate Tembeka Nkatobi, he happened to be with the Premier at the time of the writing of the terms of reference of the commission, and he very savvily convinced the Premier to add 2 terms to the terms of reference. The one being, what is the role of the villages in Moruleng, which is the seat of the Bakatla chieftainship, in the acquisition process? That was how it was framed. But so, what is the role of the community in the decision-making over their own assets? And finally, the flow of financial benefits in any of the transactions conducted on behalf of the Bakatla. And so this was a game changer, these 2 terms of reference. And so the LRC represented La Mosa as an amicus before the commission and focused almost exclusively on these 2 terms of reference. The commission sat for more than 2 years, and an extraordinary amount of evidence was led and shared, and I'm speaking today about what we learned. I'm going to say very little about the leadership dispute because that was not our focus. All I want to say, which I think was fascinating, is that there were many contenders who each had their big legal team and led evidence as to the content of the customary law of the Bakatla and the history, to the exasperation of the chair. All these different versions were often wholly contradictory, as we know, and as the Concord has also had to deal with. But what was really interesting was that over the 2 years, it was clear that while political or legal theater was playing out on the stage of the Rustenburg Civic Center in front of hundreds of community members, backstage, behind the scenes, these different contenders to the throne were not negotiating for months across the 2 years of the commission's sittings, and testimony changed as deals were struck behind the curtains. And it really became clear towards the end that a settlement had been reached amongst the contenders as to who they.
The big issue is that there are very limited landfills and sorting stations. So what happens is that most reclaimers resort to storing their reclaimables and sorting them where they live. So this is usually in violation of the zoning schemes, but also there is a need to consider what the sustainable solutions are, because even in the evictions that are successful, we find that many reclaimers end up.
A lot of money came in, but by December 2016, the Bakatla traditional administration was bankrupt. So the question really was, where on earth did the money go, and how did the leadership get away with it? now I should say it is estimated that about 5 billion rand came in and left the coffers of the Bakgatla over the 10 years. Only 2 billion of that could be traced by the Commission. Another 3 billion is still unaccounted for. Now, where did the money go? Very briefly, in perhaps 5 different directions, so to speak. Firstly, the deals with the mining companies were, structured in a way that was really not beneficial to the community. So very often, a large chunk of the income from the transaction was immediately had to be paid, used to pay off loans. So it didn't really come to the community. Secondly, an extraordinary amount of money went to consultants, mostly unregistered financial advisors. Some of them changed their name over the course of the 10 years. But one such advisor, for example, earned 435 million, and then another 25 million US dollars for advice between 2007 and 2012. So just extraordinary amounts, and it's very difficult to see what was done to earn those kinds of money. Then monies were deposited into escrow accounts and with big law firms and trust accounts, but these accounts were not regulated at all in the way that they should be. And in fact, before the Commission, more and more trust accounts were uncovered that were never disclosed and that the community didn't even know existed. Then a lot of money also went into what the chief called his incubation of community-owned companies. So he would form a lot of companies, have family members as the directors, and hundreds of millions of rands would just flow into these companies. These companies would never do anything that could make any kind of profit, and so that money just disappeared. And finally, massive investments like building a World Cup stadium or buying a television station that had little return. So the important question for us is, how on earth did they get away with it? And this is what I quickly want to say, and where I think we can learn the most lessons. And I think I'm going to speak about 5 ways, 5 enabling factors that allowed for this to happen. The first is that the community, the chief created this community corporate hybrid, which really, and he testified for weeks on end on the stand. And what was evident was that he very, very cleverly made sure that he could not comply, or he could not be expected to comply with any regulatory legislation. If you call him out on the Companies Act, he says, the Companies Act doesn't apply to us because we're a community-owned company. We're the holding company is indeed the traditional council. They cannot comply with the Companies Act. When you try and hold him to complying with traditional governance legislation, he says, well, no, this is not actually community money because we sent it through companies. So he was always falling through the cracks between different legislative schemes, and it seems absurd, but it worked a charm. And in fact, he was managing and spending public funds, community funds, without any of the requirements normally applicable to public funds. And just I give you there an idea of what the corporate structure looks like of the Bakgatla. And you can see at the top is the community, the office of the Hosi, then the traditional council, and the traditional council holds the administration as an NPC. It holds a trust. The trust is the 100% owner of a company, Bakgatla Investment Holdings, which in turn is the shareholder of a series of companies all the way down here. So now you should be asking me, how is it possible if the Northwest legislation required all income of a traditional community to go into the D account? How was it possible for the money that flowed into the community or the traditional council to not go into the D account, but to go into all these companies? Well, because he simply did not comply, simply ignored the Northwest Act. And when he was confronted about that on the stand, Khosi Pelane, he said, well, we can't be expected to comply with these kinds of government regulations when we're dealing with mining companies, because mining companies are in a hurry. They can't wait. And that's why we just had to do our own thing. Now, we can talk later a little bit about how we're trying to dismantle the structure, but maybe in questions. Now, the second key way that helped them to get away with it was, of course, the unbelievable failure of corporate governance in all these companies that you now saw. José Pelane was the chair of the board of every single community company, and he just had family members or other loyalists with him on the boards. At the commission, it became clear that none of the most basic corporate governance requirements were followed. From financial statements to conflict of interest, to transparency and shareholder meetings, none of this was complied with. The forensic expert of the commission, he said that the key problem was that there was never any consolidated financial statements for all these Bakatla companies, which means that you never know, you never have an umbrella view of where all the money comes in and goes out, which means that it can disappear between the cracks, which indeed it did at a massive, massive scale. And I should say he recommended not only that they be declared delinquent directors, that the Bakatla be put under administration, but also that criminal charges be laid against these directors. The third key way of getting away with it is centralizing the decision-making in this community entirely. So we got extraordinary insight to the commission as to how decisions are made in this community. Traditional council should be chaired by the chief. In this community, it was chaired by the brother to the chief, and some brave community traditional council members testified at the commission of the absolute culture of fear and deliberate withholding of information at the council, and where you would just expected to rubber stamp any decision by the chief. In addition, if anyone became a little bit curious, asked too many questions, in particular in some of the royal family structures, typically what would happen is they would create a new structure within the community and appoint all the unhappy people on this structure and start paying them monthly salaries, which meant that really that kind of dissent went away. But ordinary community members, the 100,000 people on the ground, did everything in their power to try and get information as to what was happening at the traditional council, but they were completely barred from getting any information through lawyers' letters on behalf of the traditional council. I'm not, this was just...
For me, sorry, just a time marker, 5 minutes remaining. Thanks.
They were just, these are some of the resolutions at the commission, just so you can see here, for example, a traditional council would take a resolution to spend 175 million on building a World Cup stadium. And this was typical, there were dozens of these discovered at the commission. Now, this is exactly what Tiani and Aisha was talking about when they were saying the TKLA makes it now even easier for traditional councils to take these kinds of resolutions and enter into agreements in the way that the Bakatla did already. The next factor was the government's failure to hold the traditional community to account. Again, the community members of this community did absolutely everything to try and to raise the alarm with the government. It's extraordinary the lengths they went to, and they just kept knocking on closed doors, refusal from all government departments to help them. I should also say that it was very clear, and the province was open about the fact that they knew that José Pelane was flouting the law and not depositing money into the D account. They did nothing, however, and in the words of the Auditor General on the stand, he said, "We knew they were running several unlawful accounts, but we didn't know officially, and therefore couldn't do anything, apparently." And finally, private sector collusion. So there was quite extraordinary evidence in front of the commission of how mining companies, financing ventures, law firms, our biggest law firms, all assisted this chief to find ways to evade regulation. And in fact, finally, the financial advisors were probably the biggest winners in the whole debacle. Now, what do we learn from this? Finally, first of all, I would say, and this is grounded in customary law, that we should ensure less rather than greater concentration of discretionary power in the hands of a few. It cannot be that we have small groups of people taking decisions on behalf of communities of 160,000. That decision-making power must be devolved, and as we see from the TKLA, it's getting worse. Requirements for accountability must be measurable and enforceable. At the moment, a community member who has an incredibly corrupt chief can do absolutely nothing about it. There is no mechanism, and this community is evidence of that. Just to note, the problem with the corporatization of community structures is also that as shareholders, of course, they don't have the kinds of power that a shareholder normally has. A community member can't sell his share in the community. So, you know, there's absolutely none of the normal accountability mechanisms if the community is corporatized. And yeah, I mentioned here that the Framework Act failed in its express function of democratizing traditional governance structures. The TKLA has gone so much further. The TKLA has removed all references to democratic principles in traditional governance, and in fact has made it even more difficult for customary accountability mechanisms to be used. I'll stop there. Thank you, Monica. Sorry if I was long.
No, it was perfect. Thanks, Wilmin. So as Wilmin is exiting, we'll move on to Nokwanda Sihlali, who is also a researcher at LARC. And Nokwanda will be speaking about community struggles and how they've been exacerbated during the COVID pandemic. Thank you, Nokwanda. Go ahead.
Thank you, Monica. I'm sorry, guys. I don't have a PowerPoint presentation, so you'll just have to listen to my voice and see my face. I'm so happy to be here today to share my part of, or the practical side of some of the things that we've been doing at LARC. As Monica has introduced me, my name is Nokwanda Sihlali. I'm a land researcher at LARC. My presentation centers on the running thread from previous speakers today as well, that COVID did not highlight new inequalities that have just sprung out of the blue for us. However, it's only exacerbated those issues, and I will take a more practical approach in highlighting that specifically access is at the core issue. Access to resources and information has been the greatest challenge for rural citizens before the pandemic, and it's still continuing. I want to use case studies from KZN communities that we work with to illustrate the issues that have not been miraculously sprung up by COVID, as I said, but ones that have been exacerbated by it, specifically at the beginning of the pandemic under the harsher lockdown conditions. And most of this information was coming to us, obviously, because our primary work is research, but then we go and disseminate information through workshops or through any sort of collective gatherings that we do with community members. Because of lockdown, obviously, this is something we couldn't do. Community members weren't calling us to ask, so when's the next parliamentary meeting? Are there any updates on any of the laws that are affected? They were calling to tell us, I'm hungry, I need money for the kids. Somebody that I know has been infected with the virus. How do we get information about it? How do we get masks and all of those? So our plan then was to take all of this information, consolidate it, obviously, because we don't work in a specific space of providing all of these things, but finding ways and solutions, because now our work has also changed in a way. So I will be using primarily the KZN examples because those are the people that I was specifically working with. So Ubab Kwankwa, from Pamshela contacted Lark asking for assistance with the water issue they had been having. He explained that the words of the president asking citizens to vigorously wash their hands to ensure that they do not transmit the virus was an impossibility without access to water. Water was only getting delivered once a week with 2 big trucks to select parts of his areas. Others actually used water from the river for their daily needs. Lark contacted the councillor of Ipamshela, who explained that the water issue is not only a ward issue, a ward problem, but also a district-wide issue, and he tries to deliver water effectively, even though sometimes community members destroy and steal water facilities, which sets the progress made with accessing water back. Ubaba also asked that they receive assistance with getting farming resources, as he is a subsistence farmer. However, he does sell some of his produce at the local market. The problem was that under lockdown, specifically level 5, he needed to obtain a permit to sell. This was an issue that NGOs took up with the president, highlighting that 70% of South Africans below the minimum wage line rely on the informal market as a primary food source. Even information about the 1.9 billion C19 Disaster Agricultural Support Fund from the Department of Agriculture, Land Reform and Rural Development was not shared. Trying to get application forms online, it would have been fine. However, because only essential services providers were working under level 5, there'd be no place to print them. His next option would have been to travel to Pietermaritzburg, which was about an hour away, where the nearest office of the department was. However, because of travel restrictions, he was unable to go. As another resort, Lark researchers also contacted the KZN department for how Babu could apply specifically for another grant called the Smallholder and Communal Farmer Support Grant, which the department set at 680 million aside. We were directed to the Richards Bay District Office that Pamshela falls under. We contacted an official who directed us to another official who eventually told us that we missed the 22nd of April deadline. Again, access to information was a problem here because most of this information was new to Ubab Mkwangwa, and it was shared by us for him to go to the councillor or to go to the traditional council to ask for this information. But now naturally we've missed the date to apply for that. The problem with lack of access to information is also a problem that Umamlina from Jozini complained about. She mentioned that she had a similar problem accessing the essential worker permit because she also runs a funeral parlor and wanted to ensure that it would be open during lockdown to secure at least one form of income. She managed to finally obtain the permit, however, not without back and forth hassle between the municipality and the traditional council. She, however, informed Lark that the Department of Small Business Development has also issued COVID-19 SMME relief funding, to which she applied. The department has received over 35,000 applications and allocated 513 million towards the SMME debt relief. Mamlina, as the main breadwinner, has been trying to find ways to ensure that her more than 5-person household does not starve. She had applied for the special COVID-19 social relief of distress from SASSA, which had promised 350 to unemployed South Africans. From all departments, she had received no response. Even now, as I had checked in with her, she has told me that all the departments that she had applied to, except for SASSA, had not responded. Reverend Mavuso of Makasaneni in Melmoth explained that for his community, the initial lockdown stages were good on paper, but not necessarily when interpreted into action because of the rural context. Big retail stores where most of the monthly groceries done are situated in Melmoth town. Under level 5 regulations of the lockdown, no taxis were meant to be operating outside of instituted times, and they were also instructed to limit the amount of passengers they could have in a car. This was an issue for the taxi operators who started to charge the community 1,000 Rand for one round trip to town. And because not many other passengers could ride in the vehicle, the amount would be split between the few commuters, which in the climate of job losses would be exorbitant. However, because the community leaders were efficient in dealing with the matters of crisis, they ensured that they spoke to the taxi operators who agreed to lessen the amount. The invisibilization of rural communities by government when they are left out of conversations that shape their lives was and still is another area of concern. Last year, August, Parliament held the upgrading of land tenure rights amendment bill public hearings. Nationally, they were held virtually, but provincially, they were in person plus virtually. The objective of ULTRA is to allow certain rights in land that were systematically weakened and undermined by the apartheid government to be upgraded and converted into ownership. However, there were no proactive means made so that rural citizens could participate, even though Section 19 and 20 of the bill affected them directly. In trying to bring in the rural voice at the national public hearings, I presented with Ubabmlungisi Kanyeza, who's from Watinabakubo. But to our surprise, him having presented nationally, we also then tried to go to the provincial public hearings. We were quite surprised to see that his traditional leader was at one of the KZN public hearings, because he had mentioned that he had no clue that these public hearings were happening. So again, as my colleagues have emphasized, the relationship between government and traditional leaders is very symbiotic in that they always favor each other. So whenever there's public hearings, we've been to many public hearings, specifically over the past 4 years that I've been at LAG, traditional leaders are always in the front seats of these public hearings. And then you'll ask, but where are the ordinary citizens? They'll tell you, no, the traditional leaders are the ones who then go home and disseminate the information. But because we know this is something that rarely ever happens, people, then the rest of the community is locked out of accessing information about laws specifically that affect them as well. So that's why we were quite taken aback that the traditional leader was there. And then even after that, Ubab Kanyeza informed me that the traditional leader, his specific traditional leader, had not shared this information to say, I went to this upgrading of tenure rights amendment bill public hearing. This is what I found. What do you guys think? What should our inputs be? So also that sort of gap is always filled, I found, by NGOs, research centers who deal specifically with those issues. Okay, yes. And then Chisimani was also another organization that tried to bring in urban activists to also contribute, but leaving the work of inclusivity and information dissemination to the social justice sector is unacceptable. PMG published a report last year in which they shared the difficulties of Parliament going virtual, explaining that lack of access to the relevant legislation, language, and literacy barriers, ineffective communication methods on the part of Parliament, and the general elitism that accompanies lawmaking and the legal fraternity are compounded by the digital divide. As Aisha and Tiani also spoke about the Stop the Bantustans campaign, that was also something that we found was a moment that government could engage proactively with the social justice space or the sector, but more specifically with communities themselves, because they went all the way to Pretoria and then went and marched to the union buildings in 2019, waited for several hours outside of the union buildings for someone to come out. And only hours later did a representative come to take them or to collect the memorandum. At that point in time, it's very, very telling of the feelings or how government disregards rural citizens themselves. So that was a moment for them to say, specifically because the issue was do not sign the TKLA or the TKLB, into law, it's going to have enormous repercussions for us. Yet they were silenced, yet the voice is not acknowledged again. And then we found, obviously, because now the TKLB is the TKLA. And I think just in me closing, I did not expect that I'd be done so quick, Monica. I apologize. I think we can play a little music video or something after here. But I think it is very important that we as the social justice sector refuse to take on the duties of government and keep finding ways to hold them accountable. Access to simple things such as government gazettes, bills in our native tongues, application forms for COVID assistance need not be an exclusive space, but a right for all South Africans. And that's just something that I wanted to highlight because it kept coming up with people sharing their stories over and over again. It's like, there's a lot of money coming out to assist me specifically as a rural citizen, but I don't have access to the information. I don't have access to the resources to get that thing. So again, it's just a very exclusionary way of engaging with rural citizens, but also it's an invisibilization of them by prioritizing traditional leaders as not as custodians in the way that we understand, but as, I don't know, leader even sounds quite passive, but just as authorities that cannot be questioned and just do a top-down or dissemination of information without consultation, obviously, as Aisha had emphasized. So I think that's what I wanted to highlight and to share some of the things that came up for us as LOG last year with our communities. Nyabong. Thank you, Monica.
Thank you, Nokwanda. Your timing was perfect. No need to apologize. So you all will have seen that in the chat, I posted what I'm calling a poll question. What is the biggest issue facing rural communities today? And you have 9 options, one of which is other. So we've got COVID-19, environmental damage, lack of secure land access, food insecurity, corruption, water scarcity, unaccountable leadership, and unresponsive government. And if you think it's something else, please let us know what it is. So if you leave a comment with your vote, I think it would be quite interesting. Sindiso, you can't vote for all of the above. The question is, what is the biggest issue? So please, at least one option. But yes, I agree, they are all issues. We are intersectional thinkers, but sometimes you have to prioritize issues. Yeah, so I think that this would be very interesting to see what everyone's responses are. So as we go into a Q&A, please just leave your responses to the poll. So I think that the 3 presentations really worked very well together and spoke to each other. I was quite struck by how Nokwanda's points about rural voices being silenced linked with Wilmin's telling of the Bakatla story and how people tried numerous times to alert government to the problems that they were facing, to the lack of accountability, lack of access to knowing what was happening with the finances, lack of benefits, and it was all falling on deaf ears, and there was no response. And I think that links very well also with Tiana and Aisha's points about the TKLA, that it doesn't provide any kind of direct means for people to have accountability when leaders do things badly or when they act, when their conduct is wrong. And so where do people go? How do people enforce accountability that doesn't require them to go through another institution? So I just thought that was an interesting thread across the 3 presentations. So I'm going to open up for comments. I'm going to let all of the votes come in and I'll have a look at them later, see if there's any kind of pattern emerging. But if there are any questions, please raise your hand. I don't see any comments yet. Okay, so we've got Erica and then Alison. Erica, please go ahead. Erica? And if speakers asking questions would like to switch.
I was trying to unmute. I'm unmuted. I can even put do my video. Okay. I found the speakers absolutely fascinating and this session really excellent. Thank you. My question is this. Mining companies, I'm thinking specifically of mining companies because I've just been doing some research for Corruption Watch on it. I think Vilmian has helped me a little bit along the way. Mining companies don't have to enter their deals with traditional authorities, traditional councils. We need to remember that when they do, the money goes into the D account. And that's the partnership or agreement that they enter into in terms of Section 23 and 24. But they don't have to. And I think it's really important for activists who are working with mining affected communities to be really advocating that mining companies must interact and form the deals with the community affected, with the people who are living on the land. They own the land, not the traditional council. The traditional council is a political body. It doesn't own the land in many cases. So I think we need to I think that's my interpretation. I mean, you can question whether I'm right or wrong, but that is my take on it. And in fact, the South African Human Rights Commission report on mining done a few years ago says the same thing. I had a quote from it in our report, that there's no compulsion to deal with traditional authorities. So I'd be interested just to hear what the speakers, how they respond to that, my point there. Thank you.
Thanks. Alison, you can go ahead and then Nicola afterwards, and then I think we'll go back to the speakers.
Thank you. I wanted to ask a question about the role played by the judiciary in the Northwest. And I'm thinking particularly the role of Deputy Judge President Hendricks, who he on his third interview, he was successful in his appointment as the Deputy Judge President. In previous applications and interviews with the JSC, he was called out on what seemed to be a suspicious pattern of decisions made, which always seemed to favor Kgosi Philane. The appointment was stopped in 2017 because there was a complaint that was actually with the JSC, and we had repeated the assertions made by Anenka them in a paper written about the difficulties around the various decisions that were being made in that division, particularly in relation to freedom of expression. Institutionally, the judge president in that division was very much in favor of Hendricks being appointed as DJP, and she actually scuppered the chances of another candidate who was in the running for DJP. That being said, it is my view that it would have been better if Hendricks had not been appointed as DJP, and that a formal complaint had been laid with the JSC in order to ventilate these issues. Without that complaint, there was nothing but these assertions, and the JSC was able to appoint him on the third time round. So my question is do you, and I'm not sure which one of you would have the sort of the closest, would be the closest to the issue, but what could have been or should have been done about Hendricks, And is there still room to do something going forward, assuming that there is, some support or concern around Hendrix's behavior? Thanks.
Thanks, Alison. Nicola, go ahead.
Sure, thank you. Thanks. I also thought it was such a brilliant panel. I just wanted to quickly respond to, I think it was Eric's input. In my experience, when you speak to minds, they just say, we want to, or the undertone of what they say is they just, want to do what's easiest and don't really care too much about what actually happens with the money. And the one thing that local municipalities and minds always repeat, they always say, there's so many community forums. There's a new community forum every week, every day. And so then basically they're saying is we can't do it directly with community because every day there's a new forum popping up and how can we trust them? And there's fights with the community forums. And so that's the justification for doing it with something like a more established traditional council. And what's interesting is that, when you try arrange a meet or even get something from a mine or arrange a meeting with a mine, they often say like, does the municipality know about you? Or they just surprisingly like have someone from a municipal manager or something in the meeting when you didn't even know they were going to be there. And so for me, the question, I think it's something I've thought a lot, but how do you have, how do you respond to that comment where they always say, there's no legitimate body that we can trust beyond the traditional council established, where the community forums are always warring with each other. And I just think that's the excuse that they often use to not enter into agreements directly with the community. Thanks.
Thanks, Nicola. Eric, I don't know if you want to respond immediately to Nicola's point or if I can go to the speakers.
I just wrote in the commentary that I think you're quite right, Nicola, but I think this is a struggle area. It's an area which one has to contest as much as one can, and I think that's the only way to deal with it as a sort of a strategy mining effective communities have to develop. There is no real answer there, because I think you're quite right.
Great. So it looks like so far in the polls, we have access to land, or lack of access to land rather, and unaccountable leadership seem to be winning, if that's the right word to use. But we've had some interesting additions, some people saying unemployment. There was one comment, a real democracy from Sam, I think, and a lack of knowledge or lack of awareness. That is also a problem. Yeah, thanks, guys. Please keep voting if you haven't yet. Okay, so I'm going to go to, I think, Wilmin first. I think she'll be able to address quite a lot.
I'm really keen.
So please go ahead, Wilmin.
Okay, thank you. No, I'm keen because these questions are so useful and they all have to do with one another. So to start, Eric, I mean, I can't agree with you more. That's also how I understand the legal position. The problem is multiple, and I agree with you that should be our struggle, and that's why we talk about decentralization. But the problem is multiple. So one, the government doesn't understand it that way. The government understands traditional leaders to speak for their communities, and they tell. So at the Kgalema Motlanthe high-level panel, the Chamber of Mines was confronted about this, and they said, we know we're not always, that the traditional councils aren't always legitimate, but the Department of Minerals orders us to speak to the traditional councils. And by the way, Khosina Lalapalane that I mentioned, he is the community representative on the department's mining council. So he speaks for communities all across South Africa, so you would not be surprised, right? So that's the one problem. Government departments all see it that way. Secondly, exactly what Nicholas said, mining companies much prefer dealing with one structure. So for example, Sibanye Stillwater has taken over from Lonmin in Marikana, and Lonmin had such a nightmare there, as we know, not only because of Marikana, but because of the Bakubamukale and everything that happened around that community and all the money that disappeared from the D account. They met with us shortly after taking over to ask kind of, I don't know, it was a PR exercise, I guess, but to discuss as to how they can do things better. And the one message we tried to get across was, please do not fall into the trap of engaging with the traditional council, the chief as the representative. And their answer was, oh no, that's definitely what they're going to do, because there's now a new chief after a commission of inquiry, so all the disputes are at an end, and so they definitely cannot possibly go beyond that. So that's certainly mining companies can't say they're forced, that is their preference. And finally, and this is where I get to Alison's point, the judiciary also has this unbelievable reference for traditional councils and chiefs, largely. So in the Northwest, and yes, absolutely, Alison, there's not a member of the Bakhatla community who doesn't know the name Hendricks and can tell you lots of horror stories about him. It's a very litigious community. They've gone to court several times to try and get rid of their chief, their traditional council, just expose the corruption, just get information, and they're thrown out time and again based on standing, which Monica and others have written extensively on it. So based on this idea that the traditional council or the chief is untouchable, and it's about contestations over who the royal family is, but principally it's about the fact that ordinary community members are not regarded as people with any kind of say by many of our courts. And we've experienced this in North Gauteng High Court, in Bishu High Court, where you get a judge who just says, not in my village, can you say something against the chief, and kind of takes judicial notice of that. So it's an entire culture that we're up against. Of course, that means that a victory like the incredible victory in Maledu in the Constitutional Court, that makes that so important, because that's the case in which the court said, well, you were not right in speaking to the traditional council. You should have spoken to the directly affected people. And it was a massive blow for that mining company. So, I mean, in the end, that's probably the way we're going to force the hand, with mining companies feeling the pain of having to go back after consulting with the wrong people. So who you consult with, I would say the directly affected land rights holders. If you were not in a traditional community, that's who the mining company, they will go door to door to every private property owner. They will never speak to one person on behalf of the whole community. But they do it in rural communities as if those are not people, as if their ownership is not real. And that is ridiculous. I'll stop there.
Thanks, Momin. Tiane, I saw you come on to video. So would you like to make any responses next?
No. I was just excited by Velmin's responses, which I absolutely agree with. And I mean, just one minor contribution that I will make in addition to Velmin's. I think these questions and Velmin's response bring up a point about our understanding of what a community is, that it's not this one broad, massive, homogeneous group of people, that actually there are subgroups even within communities. So when they are saying that there are factions within the community, so I would agree with Vermin that one way of going around that is actually consulting the directly affected people, because then if you're going with the idea, sorry everyone, there's a bit of construction in my building, so a bit of noise in the background. So if you're going with this idea of a unified homogeneous community, then you're gonna struggle with that, because you want one voice out of a group of people, and that's less likely to happen. So when you actually define who is directly affected, then you'll be able to go to that person directly, or to that group of people or subgroup directly. And another point that just popped in mind, it's a thought I've had for a while. I think all these issues that we're highlighting here in terms of how government views traditional communities, how traditional leaders view traditional communities, how mining companies think of traditional communities, I think for me, it also brings up this idea of traditionality, what it means. And we also know that it's a term that was used in the past, and especially during colonialism, to paint or to represent Black people in a particular way. And I'm hearing undertones of that even in this discussion, in a sense that actually government or mining companies do not see traditional communities as owners of property, as people. Therefore, they don't deserve to be, they should not be consulted with. Even judges, they don't see them as people or entities that deserve to be consulted with. And for me, that brings it down to this idea that they have been labeled as traditional community or as traditional. And that brings in these problematic preconceived ideas of then how you relate to them, because you're not seeing them as citizens, you're seeing them as traditional, therefore backwards, therefore not deserving of full consultation or don't even have legal. It's very close to that empty lands theory or idea that, when the colonial forces arrived, they just undermined everyone who was here and decided that actually these are empty lands, there are no people here. So I'm seeing that this playing out in what is happening right now in relation to how government, mining, and traditional leaders relate to traditional communities. That's all I wanted to point out.
Thanks, Tiane. So I'm going to hand over to Aisha now. I thought also to help with time, there's a question from Nolundi in the chat to Tiane and Aisha. She says, in her keynote speech this morning, Dr. Mbete spoke about the importance of engaging with legislators or lawmakers at all levels. What are your thoughts on this, especially as we head into local government elections? And in relation to the TKLA and other laws, does this help or can it help? If you can speak to that too. Thanks, Aisha.
Thanks, Monica. I'll provide a response, or try to provide a response to Nolundi's question, which, I mean, I totally agree. It's vital that there's engagement at all levels when it comes to the lawmaking process. But from our experience of monitoring the lawmaking process, the parliamentary process, we see that process itself excludes people, and particularly rural people, in the manner in which public participation is conducted and just how laws are drafted themselves. It doesn't really allow for adequate opportunities for people to even access those arenas. I mean, if you think about just the lawmaking process in general, it comes from a certain department. It's not really laws that people can inform when it's being thought of. So that in itself is already creating a barrier for people, rural people, traditional communities, people on the ground to take part in that process. Just as an example, during the TKLB hearings, there were a lot of problems with how that public participation was conducted. People had no access to information. There was no access to polls, to copies of the polls. And there was not enough public education, like no public pre-hearing workshops were held on the poll. So I think that the public participation process and the lawmaking process itself needs to be reviewed. There was a review of it a few years ago at Parliament itself, where they considered the Lamosa judgment with regards to adequate public participation. But as far as I know, maybe others can correct me, though, that those guidelines were never actually formalized into a proper guideline document. I think it might still be a draft. I'm not sure if it was ever adopted. But yeah, those are just my thoughts on Nolundi's point. Thanks, Nolundi. And just, Alison, I actually have a question for you, and I'm sure you'll be able to answer this, because as you mentioned, Deputy Judge President now, Hendricks, has handed down some really awful cases when it comes to rural democracy. And is the problem maybe that the judiciary itself is not being trained or educated on customary law, specifically living customary law, so that they are maybe automatically defaulting to a certain version of customary law that's, you know, in the statute books, or that's put forward by a traditional leader or a traditional council? Do you think that's an issue? And also, you asked what could or should have been done regarding Hendrik's appointment. What processes could Alison could still happen now? I mean, I know the GFC, there's complaint processes. Can they investigate? Can something be done if we follow the judgments that he now hands down, if there's still problems with that? I just wanted to ask what avenues are available. Thanks, Monica.
Thank you, Aisha. Nokwanda, you are still there, I'm assuming. I don't know if you want to respond to anything. I'm going to address Noludi's second question to you. So she actually addressed this to any of the panelists. So if the others want to respond, feel free. Her question is, what are your thoughts on how the varied short and long-term impact of COVID-19 heightens the already high stakes for rural communities now and in the future?
Okay, I specifically had no sort of contribution for the mining aspect because Tiani covered most of the thoughts that I've always had. But my biggest issue with government specifically will be the laziness, and with mining communities as well, is the laziness to say, okay, if there's so many people to consult, how can I find innovative ways to engage with that? There are so many research units that work on so many varied aspects of the mining sector that if you just go reach out and look at reports from any one of those, collate a system or come up with a systematic way of doing consultations, there's no inability to engage with human beings, especially those who are going to be directly affected by being removed. Now, next thing you're going to say, we need to remove your graves. I mean, if you're removing intangibles, there are processes that also come with that that don't include money. I need to talk to the people, to my ancestors, and tell them I'm being removed so that I can go to a new place. I'm taking your body. And these are the things that specifically Dineos Kosana's research, when she speaks about graves matter, it's like you don't, I'm not humanized. I am an object that can be removed during the 1950s, and again in post-democratic South Africa, I can be removed again. I sometimes think about the fact that if we were to go to UCT and just say, we found gold here, all of UCT needs to just move. We found gold, we need a mining right. We will burn Cape Town down because we will not move. So why is it that my grandfather, Makaya, is just easily removed from a space that he is so connected to spiritually, emotionally, and also just collectively as a community? I mean, there's very much, language is very important in how we engage with any of these things. So being specific about and deliberate about noting community, what is a traditional leader? And also, as Usindiso says there in the chat, we need to understand that in as much as communities are not homogeneous, also traditional leaders, we've never come to the conclusion that every traditional leader is a bad traditional leader. Sometimes they also have hindrances that come from government, hindrances that come from being the person who's a conduit between government and the people that you're supposed to be sort of leading, and also a custodian of the culture and the community. So it's very, very important also for us to engage with those things. But for me, they come down primarily to the laziness, just to be very crude, just the laziness and inability of government and specifically mining companies to do this. I mean, in sort of engaging with Unoludi's question, especially the the long-term effects of COVID, I would like to speak. The long-term effects there's too many, but specifically, one of the short-term ones that came up is when I attended one of these meetings of the department, the Portfolio Committee of Agriculture and Land Reform, and the commissioner came to present, and it was a great presentation. And for me, it highlighted a part where some of the MPs also emphasized that the commission could not complete the verification and research aspect of a restitution claim because of COVID. We can't have in-person meetings. So if I see all of COVID specifically and when it started, how to engage with things like researching and trying to finalize a claim is difficult because I need to go and investigate. So you say you're a member of this community. Okay, how long have you been here? Okay, so I need also forms. I need things from you. So it disturbed so many things within and the moving of money specifically to attend to the COVID relief. The department, Department of Agriculture suffered tremendously. They have so many judgments against them that they've lost, that they need to implement. And even with the Ingonyama Trust, they've lost that judgment, obviously, at the Pietermaritzburg High Court. Now they have an implementation plan of how they're going to deal with the PTO and leases issue in KZN. They're setting aside 5 million for it, but they're also understaffed, but also they don't get much money from government. And then also already they have their annual projects that they already have, but then now there's all these other things coming up left, right, and center, because the information that you need, there's no need for Rahube or Mrs. Rahube to take you to court and say, listen, you've upgraded my brother's his document into a title deed. Now he's evicted me from the home. So I'm coming to you as government and holding you accountable for this law that you created that doesn't consider me and my rights as a woman. So there's no need for that, because they can just sit down and look holistically what is happening with these laws and how can we make sure that they speak to each other in a post-democratic sense. And also, we as the NGO, I feel, or NGO, or also just the sector, we are so available to provide them with so much information. It's the most easiest thing to do, because even with the ITB implementation plan, there are so many problems there, Monica. You will not believe. But I'm just like, everything is in the judgment. Like everything that you need to do is in the judgment. There's no need for you to reinvent the wheel. Why is it so hard for them to engage with these things? So I mean, just that, the commission not being able to do research because of COVID has delayed already. There's so many land claims that are there, but the issues will still be continuing. So yeah, that was my input. Thank you, Monica.
Thanks, Nakwanda. So I just don't want us to lose one question. So there's a lot of interesting stuff happening in the chat, which I can come back to, but Tasnim had their hand up earlier. I don't know, Tasnim, I see your hands down. Would you still like to? Go ahead, please.
Yes, please. Thank you. So this is a question, it could be for any of the panelists, but I guess also will mean because it's, I know she's from LRC. In terms of customary land rights and just the general activism and litigation around this, what is, as public interest and public interest organizations, is there anything we can do just about the role of private law companies, where I think it's, because mining companies, and because then, you get horses who have so much money, so much access, that there is almost this unfettered power in terms of the law, where, I mean, of course, there's amazing work being done by LARC, by LRC, by Siri, all of that. But at the end of the day, it just sort of feels like, is there any kind of legal strategy or some sort of strategy to deal with the fact that there are these sort of big law firms that engage in very exploitative practices, that basically, because they have all the money and resources, it's the chances of a community winning in many ways, it's stacked against them. So I think that's just kind of my question around that. Thank you.
Thanks, Momin. Would you like to address that?
Yes, it's a very difficult and interesting question, especially so. At the time of the commission, when we realized what the evidence was showing, and that reputable law firms were getting away with murder, so it made me personally very nervous because I'm a lawyer. So I, because of the professional ethics and all of that, and so I was extremely nervous of exposing it. Although we did, in a sense, I mean, we published articles about it and so on, but it didn't really get any traction. And I wonder about it. I've always, and maybe I shouldn't be nervous about it at all. Maybe it is something that we should be open to addressing, but it's actually a conversation that I would be extremely interested in having with other lawyers and other groups in the space, like yourself and like LARC, as to, I think it's an incredibly important point, and how do we address it? So it has two components. I think the one is that you mentioned, I mean, they just have resources that's just endless, and to fight that is very, very difficult. But then also, they do bad things, and how do we expose that? So I don't have a good answer for you, except to say that I think you've raised something incredibly important, and I would very much like to have a conversation about that and how to tackle it.
Thanks, everyone. We've been given an instruction to convene a discussion, which we will contemplate, Lisa. Yeah, we've reached the end of our session. A request, great. We've reached the end of our session. Thank you so much to everyone. Thank you to the presenters for your wonderful presentations, to the discussion that was happening in the chat. It was really rich. So I would recommend that people go back and read the messages if you missed any. Thank you for participating in my poll. Yeah, and I just want to speak a little bit about the program. So we're going to a tea break now for 15 minutes. And then at 3:45, there'll be a self-care session facilitated by Lucy Draper-Clark. And it sounds like it's going to be very useful after 18 months of very high levels of stress and a heavy mental load on many people in the sector. So I would really encourage you to take the time out, and put yourself first. So thank you, everyone. I think when you say leave the room, you should go back to the main, there Lisa's left an explanation. So I think when you leave, you'll go back to the main room. Thank you very much. Thank you, everyone.
Thank you, everyone.
Thanks, Monica.
Thanks, everyone. Bye.
I'm just sticking around because I want to say hi to a few people. Hi, Monica. How are you? Hi, Risha. How are you?
We're doing okay, thanks. How are you doing? It's so nice to see you. I didn't realize you were coming.
Oh yeah, no, I I didn't want to miss it, especially your guys' panel. So I thought I would try and log in. How's the baby?
Oh, he's adorable. Am I allowed to say that?
Yes, of course. In fact, I think it's your job to say that. Like, if you don't say it, then like you get into trouble or something. They call the police on you.
No, he's a very sweet baby, which makes things nice. Yeah, no, he's doing well.
Awesome.
Almost, he's 9 months already, which is insane.
Oh my goodness! I was gonna ask how old he is. Oh my goodness!
No, he's 9 months already.
Monica, I can't believe it. Like, it's like 2 months and he's going to be 1.
Yeah, it's insane.
Hi, Cindy.
Hi, Aisha, how are you?
Hey, thanks.
Sorry, let
I
me
just
see.
need to go and make a cup of tea now.
I look a
because-
little like disheveled, but you know, oh, they're still recording. They're still recording, so you don't get to see me. Because I look a little disheveled, like it's morning here, because it is. I literally like just hopped on the computer and I was like, okay.
Yeah, well,
So,
that's
yeah.
understandable. It's also cold, I'm assuming.
It is. It's starting to get chilly over here. So, you know, ish, guys. I miss home, especially at this time.
I can imagine.
Yeah. Are you guys planning to come down? Sorry.
Oh, you know, I would love to. I really would love to. It's just